Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision out of the Ninth Circuit Court of Appeals by way of California. This is the case of Samantha Vasquez versus the County of Kern. In this case, prison guards at a female facility for minors, one of the prison guards was male, and the male was engaging in what we would call extremely creepy behavior, as we're about to learn in more detail. The prisoner, this minor female, has brought an issue that they were being mistreated. And so we're going to determine whether or not they can recover under 1983 cause of action or whether or not this qualifies as qualified immunity. Was it totally cool that the prison guards did this because they didn't know? Or was it totally not cool because they should have known and it was super, super creepy? So we're going to read the decision and see what happens next. Vasquez entered Kern County Juvenile Hall in January of 2015. She was housed in Unit 300A, an all-female unit where Anderson worked. Juvenile hall staff frequently placed wards on details, including laundry, kitchen, and cleanup. So we have a jail with an all-female unit for juvenile offenders, people under the age of 18. All-female juvenile. Okay. Vasquez contends that Anderson purposely selected her to work on details with him. During her deposition, Vasquez testified that Anderson said appropriate things to her, such as calling her babe and telling her she had a big butt in the juvenile hall pants. Vasquez also testified that Anderson grabbed her face, touched her shoulders, and talked with her about her shower gown. Juvenile facility, under 18. All female. Male prison guard, not under 18. This is a little bit disturbing, yes. It gets worse, Unicorn. It gets worse. It doesn't get into sexual assault worse, but it does get worse. In her testimony, Vasquez, and by the way, I'm going to be responding to Unicorn Cupcake in chat for the rest of the day, even without super chats, because she's a fan of mine and didn't know who Leonard is. It is a she, right? Hopefully. So, yeah, I'm assuming. So Unicorn Cupcake for the rest of the day gets the privilege of me talking to them because they were a fan of mine, not Leonard's. So there you go. Everyone else can super chat their way into my hearts. Yeah. You show favoritism to me, I show favoritism to you. Seems okay, guy. All right, sorry. I with a name like Unicorn Cupcake. Yeah. Okay, but no. Yeah. Isaac, you don't know who that guy is? Then you also get a +1. +1. Who else? It's my daughter uses this name too. Okay, well noted. Yeah. +1 to Isaac. Yeah. Isaac Wicks. Isaac Wicks gets +1. They get to be an important person. A lot of people don't know who Leonard is. So +1 to Mosaic at Mosaic Task Force. You get a smiley face as well. Everyone who's a fan of mine directly gets a smiley face. Thank you. In her testimony, Vasquez described one specific incident where she was working on detail with Anderson and told her about a dream he had about her that was rated R. She testified that he told her to shut the door and then told her details of the dream, including that, in the dream, she grabbed him by his t-shirt, gave him a kiss, and after that, they ended up going to a room and having fun and stuff. All female. Juvenile facility. Adult male guard. Yeah. After that, she testified that he told her to get close to him, to the point where we had opened the knees and she was right in the middle of him. And he told her that he wanted to make his dream come true. Vasquez testifies that she moved away from him and after felt really, really awkward. Isaac. You wouldn't be lying to me, would you? You wouldn't be lying to me that you don't know who Leonard is when you said I'd have no clue who that guy is. You wouldn't be lying to me, would you, Isaac? Lying is bad. Are you lying to me, Isaac? Please don't lie. Lying is bad. Lying is the devil. Are you gonna break my heart, Isaac? Is that what's happening? I do have no clue who Leonard is. Fine. That's good. But you came from Viva? If you came from Viva, that's fine. If you came from, yeah. I saw the audit, and Legal Eagle, then YouTube suggested Uncivil Law. Excellent. It's nice to know that I'm getting some. I don't know who Audit is, Audit the Audit, but I definitely know who Legal Eagle is. So it's nice to know I'm getting some referrals from that. That's cool. Vasquez also alleged that Anderson would tell her which shower stalls to use, and then he looked at her inappropriately while she was showering on 3 or 4 occasions. All female, juvenile facility, adult male guard. The guard is instructing her which shower stalls to use and watching her. Juvenile, female, yeah. She testified that she caught him staring at her in the shower when she was standing at the staff counter and she tried to cover herself up. She also testified that Anderson told her that he had seen her in the shower and that she should leave her boyfriend and find someone better like him. Wow. Yeah. Yeah. Are we talking about the Captain Marvel thing? Even though I did beat Illegal Eagle over the head a little bit on the Captain Marvel thing, even though I did beat him over the head a little bit on the Captain Marvel thing, I still think he was way in the wrong. Like, a lot. I don't even really think it's close at all. And, like, it's like, I pretty much stand by everything I said in that video. It was a little bit earlier, so it wasn't my best presentation, but substantively it was right. I'm like, first of all, this isn't assault or battery. Even if it is, the threat has passed. Even if it hadn't, her right of self-defense had expired. Even if it hadn't, the amount of force was disproportional. And even if it wasn't, she's still not justified in the taking of the jacket, taking of the motorcycle, and the extortion. So, like, at every step of that analysis, Legal Eagle was wrong. Just plain wrong. It boggles my mind. It boggles my mind. I mean, I understand that Legal Eagle is left-leaning. I totally appreciate that, and I don't mind. And I understand that I'm right-leaning, and that we might disagree on stuff. But for him to disagree to that degree with me on that issue, I'm like, it's a little bit hard not to say it's just virtue signaling. It's a little hard to believe he believes it, because it's like, there's just no way. This doesn't make any sense. It's like, could you get to battery? Maybe if you're stretching it deeply to battery, maybe, but the other stuff doesn't flow. No, and I still think it's one hell of a stretch. I don't think you get there. Yeah, New York. Yeah, the crime of assault and the crime of battery. Sometimes, yeah, New York does wrap them in. A lot of states do that. But we were talking about civil. I'm pretty sure in New York and everywhere else, in civil law, assault and battery are still distinct. I understand criminal law, they're not. But I'm pretty sure they still use those terms distinctly in civil law. I'm left leaning, and you're the most well argued conservative I know. Thank you. Thank you. I feel validated. That makes me feel good. Thank you. I like to have my worldview and opinions challenged in an intelligent way. Well, me too, man. Me too. I like listening to anyone. I've said this before. I said it on Viva's channel. I've said, I will take anyone who has a brain and can express themselves. Incidentally, while I'm thinking about it, because I'm a little bit sad about it, I was, until very recently, a member of the ContraPoints Discord server. So ContraPoints I watch her videos on YouTube. She is a male to female transgender, and she produces really, really, really quality content. I mean, amazingly quality content. It's really good. And she's incredibly well informed as to her opinions. She knows her stuff. But I made potentially the mistake of defending Jordan Peterson on her Discord. And I'd like to point out for the record, I was really, really polite and nice to everyone about it. And then they banned me for wrongthink. So I'm kind of upset about that. I mean, you don't have to like Jordan Peterson, but I was really nice. But, yeah. The investigation into all this was led by Sean Romans and lasted approximately 8 months. Romans interviewed 55 people and reviewed 3 interviews conducted by the Bakersfield Police Department. That is a very thorough investigation, I cannot deny. When questioned about the allegations against Anderson, Romans testified that in his investigative opinion, he leaned towards them being true, towards the belief that they were more likely than not. The allegations were also sustained by disciplinary review board at the probation department. Kern County then began the process of terminating Anderson's employment. So the issue here is civil, deals with your employment status. They conducted an extremely thorough investigation for this prison guard. 55 witnesses and reviewing the 3 prior people. It's like, wow, that's really, really thorough. And then they said, yeah, we think that it's more likely than not that he actually did all these bad things. Because as you might imagine, prisoners have a bit of incentive to falsely accuse prison guards. And for that reason, prison guards are aware of this and therefore may exploit that in using abuse of power because they know that they're more likely to be believed on the whole. But here they conducted an unbelievably thorough investigation, found that it was more likely than not, and then said, oh, we're going to dismiss this guy. So that was good. Well done. I'm glad that they looked into it as thoroughly as they did. So good work had by all, except Anderson, because he's really super creepy. Several staff members testified that they observed Anderson alone with female wards, that would be children. When they're using the term ward, they're using it in the same sense, like in the Batman series, Robin was Bruce Wayne's ward. So a ward is just a juvenile in the care of someone else. So normally, if it's a parent with their own child, we just call them child. We don't use the term ward. In a very technical sense, they are, but we don't normally use that term. So just a ward is just a minor, or I suppose it could be anyone for that matter. It doesn't necessarily have to be a minor, because you can be an adult and be incompetent and be a ward. It's just that all children are automatically wards unless you've been emancipated. But adults can fall into this category too. So a ward is just any person, usually a juvenile, who is in the care of any other person, whether that's their own parent, foster parent, the state, whatever. So that's a ward. Just a person who is not competent to care for themselves. That's a ward. Another staff member testified that she observed Anderson sitting at the staff counter while female wards showered. Good. Moreover, Molliner testified that Section 1425 of the Juvenile Hall Basic Rule Staff, which were in effect at the time of the allegation, stated staff members are not permitted alone in the rooms with minors of opposite gender except during emergencies. For security purposes, staff should avoid being alone with any minor in their room. So a very sensible policy, particularly when you're dealing with opposite sex. Just avoid being alone. Don't do this. It's good practice. So yeah, not good times being had here. The district court granted Anderson's motion for summary judgment of Vasquez's claim to the extent they were based on sexual abuse or a violation of Vasquez's right to privacy. First, Anderson argues that even if Vasquez's sexual abuse allegations were true, his alleged conduct did not violate her constitutional rights. The district court agreed, concluding that it could not find harm of constitutional proportions regarding the sexual abuse claim. So the district court saw no problem with this. We don't see anything that's a constitutional violation here. This is totally fine, says district court. This is totally good, no problem. Okay. Second, regarding the privacy claim, the district court acknowledged that there was a dispute whether and to what extent Anderson watched Vasquez in the shower. Taking the facts in the light most favorable to Vasquez, the district court concluded that Anderson's alleged conduct was not sufficiently frequent to violate the right to privacy. Finally, the district court proceeded to conclude that even if Anderson's conduct rose to the level of constitutional violation, he was entitled to qualified immunity. So district court says this is not a problem. We're not seeing any issues here. This is not as bad as you say. Even if we take everything in your light, it was not that frequent. It wasn't that big a deal. And even if it was that big a deal, it was not sufficiently well established at the time to form a violation under 42 U.S.C. 1983. So even assuming it was, you're still not liable for it. That was the district court. Said, yeah, this officer did nothing wrong, and even if they did, they're still immune from penalty anyway. Okay, well, that's a lot. Did the Court of Appeals agree that this officer should get off scot-free? We disagree. Oh, thank God. We hold that, viewing the facts in the light most favorable to Vasquez and drawing all reasonable inferences in her favor, she has presented sufficient facts to establish a violation of her right to bodily privacy, right to bodily integrity, and right to be free from punishment as guaranteed by the 14th Amendment. We also hold that Anderson is not entitled to qualified immunity. Wow, another police officer, or in this case, prison official, without qualified immunity. Well, maybe there is some hope for us all yet. Now the court is going to get into why this was totally not okay. The right to bodily privacy under the 14th Amendment was established in this circuit in 1963. We extend this right to prison inmates in 1985, and we've held that a pretrial detainee has at least the same right to bodily privacy as a prisoner. So there is a general right of bodily privacy. This extends in general to prisons people. It extends in general to people who are there not as prisoners but as being held in a pretrial status. So in general, there's a right to bodily privacy. Now, in the case of a prison, of course, that is going to be massively impacted by security needs of the prison. So if this were, for example, a strip search as part of, a routine thing or a result of something like that, then we'd be in a different category. Because the reasonableness of the search is going to be massively impacted by the environment. But here we're not in that example. We are here in a prison guard who is leering and looking and having dreams and trying to get on with a juvenile. So that's, not quite the same thing as we are doing a strip search because we're doing it for safety reasons, is it? Not quite the same, no. Unicorn Cupcake, just for the record, you can get your own YouTube account. And I think your daughter would probably appreciate it because the stuff you're watching is probably marring her recommendations. I mean, I'd like to think that your daughter would also like to watch the law channel that is Uncivil Law. However, I'm prepared for the possibility that your daughter may not be as much a fan, even though I really wish she should, because Uncivil Law is the best. But she may have other interests, which I acknowledge. Sadly. Here, Vasquez contends that Anderson violated her right to privacy under the 14th Amendment when he allegedly watched her shower multiple times and on one occasion locked her up in her room when a privacy sign was on, or looked on her when a privacy sign was on. First, Anderson contends the right not to be viewed naked by members of the opposite sex is protected under the Constitution, so he says there's a right to this, but he contends that there's a compelling state interest for safety and security of the juvenile detention facility for guards to be present in a separate room and behind a computer desk during the ward's shower time. There may be a compelling interest in general. Yes, watching the prisoner shower may have a compelling interest because attacks in the shower room have, of course, been known to happen. So do they have an interest in watching the shower happen? Probably. If a male guard is available and they're the only one available and they're watching like every prisoner as part of the showering, is that okay? Probably. If they're watching some specific prisoner because of prurient interest reasons, it's probably, again, less okay. So the general rule, as is often the case, does not apply to the specific, which again is why lawyers say it depends a lot. Because we can tell you general rules, but then the specific usually gets in the way. And this would be an example. In general, is this okay? Probably. In the specific, is it okay? No. Anderson's argument that there is a compelling state interest for his alleged actions is not persuasive, as there is evidence in the record that his actions, at least with respect to the shower allegations, were against institutional policy. So yeah, again, if you had been following policy for policy-based reasons, it would probably be okay. But what you're doing was not for policy reasons. It was not in service to the government. It was in service to yourself. That factual difference is going to be pretty material here. For example, another corrections officer testified that she was trained that the male staff should not be in the unit while females are showering, and if she had observed Anderson at the staff counter while female wards, that would be children, were showering, she would have reported it. A substance abuse counselor also testified that if he had observed a male staff member sitting at the staff counter while female wards were showering, he would have reported it. And the director of the juvenile hall testified the juvenile hall administrative manual required supervision of showers to be provided by staff of the same gender as the youth, and except in extreme exigent circumstances or incidental to routine youth safety check, the youth will be permitted to shower without non-medical staff of the opposing gender. So it's a little unclear then how this particular person was able to watch this, because if people are supposed to be watching these people in a general rule, then presumably there would have been some staff member who should have been there for the purpose of that and would have observed this guy looky-looing and then would have said, hey, what's up? But, the way it looks like he was alone. So it's a little unclear how that was allowed to be happen. But in either case, it was a violation of policy. Except in unusual circumstances, you can't have non-medical staff of the opposite gender watching these people while they shower. And that is not you, so that was a violation of policy. Second, Anderson argues that his alleged conduct, even if it was true, did not violate Vasquez's privacy because his view into the showers was infrequent, from a distance, and did not involve any inappropriate amount of conduct. Yet, in viewing the evidence in the light most favorable to Vasquez, even if Anderson observed her from a distance, the question of whether his observation was infrequent and casual remains in dispute. Moreover, there's evidence that Anderson directed Vasquez to use a certain shower stall so he could obtain the best view. His own little private show. Just super encouraging. Given the evidence that there was no rational connection between Anderson's conduct and a legitimate prison interest, and the evidence that Anderson's view was not necessarily obscured and from a distance, we disagree with District Court that Anderson's alleged viewings were not sufficiently frequent to violate Vasquez's right of privacy under the Fourth Amendment. Viewing the evidence in the light most favorable to Vasquez, we hold a reasonable jury could conclude that Anderson violated the right to bodily privacy. So unlike the District Court, the Court of Appeals has said, we think this is a triable issue. It's disputable. It is disputed how much this was happening. These are questions of fact. We don't know. We're assuming things in the light most favorable to the non-moving party, as always. But it looks like enough here. If a jury wants to believe the officer, so be it. If the jury wants to believe the minor, so be it. If they want to believe them both in some sort of combination, okay. But either way, we're saying there's enough for a reasonable jury to conclude this, so we're sending it back for factual finding, and jury, you figure out what actually happened. Okay. Vasquez asserts that Anderson selected her for isolated work details so that he could groom her for sex. She alleges that Anderson referred to her as babe. She told her that she had a big butt, touched her face and shoulders without her consent, talked to her about her appearance in her shower gown, told her that he had seen her in the shower, and told her that she'd like her to leave her boyfriend and to find someone better like him. Moreover, she testified that during a work detail, Anderson told her to close a door and proceed to tell her about a sexual dream that he had had about her. Again, a minor. Vasquez testified that Anderson then told her to get close to him to the point where he had opened his knees and she was right in the middle of him, and told her that he wanted his dream to come true. As did the District Court, Anderson continues to argue that even assuming the version of offense is true, his conduct was too insignificant to comprise a violation of the right of bodily integrity. Here, Vasquez's assertions are sufficiently similar to those in the prior case of Fontana for us to conclude a reasonable jury could find that Anderson's alleged conduct violated Vasquez's 14th Amendment right to the right of bodily integrity. So we're talking about bodily integrity instead of the right to privacy. Different right, so we had to do the analysis twice. Moreover, the context of Vasquez's allegations demonstrate that she was at least as vulnerable as the Fontaine plaintiff. At the time of the alleged events, this is where it goes from creepy to really creepy. At the time of the alleged events, Vasquez was a female ward, that would be juvenile, under the age of 18, at juvenile hall, whereas Anderson was 45 years old, was larger than Vasquez, wore a uniform, and had the power to discipline her if she refused to follow his instructions. Thus, a jury could find that Anderson's alleged conduct was egregious and outrageous and shocks the conscience as a matter of law. Here, Vasquez asserts facts from which a jury could find that Anderson violated her rights to be free from punishment as well. First, Vasquez alleges that Anderson's conduct caused her harm outside of inherent discomforts of confinement. Secondly, Anderson's alleged conduct did not serve a legitimate government objective. Right. And discussed above, there's evidence that Anderson's alleged viewing of Vasquez in the shower served no legitimate purpose, such as observations were against policy. Anderson's other alleged conduct, including selecting Vasquez for work details so he could be alone with her and call her babe and other things, and directed her to get close to him, served no legitimate purpose. In light of the record of the evidence, we hold the jury could find Anderson violated the 14th Amendment right to be free from punishment. Next, the court is going to get into the qualified immunity issue. So we've determined that he did a lot of bad stuff. But is he immune from it because he didn't know better? Let's get into the qualified immunity analysis. Let's see what you have to say. Qualified immunity attaches when an official's conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. The clearly established right must be defended with specificity. However, there can be rare, obvious cases where the unlawfulness of an officer's conduct is sufficiently clear, even though existing precedent does not address similar circumstances. In this circuit, it is clearly established the 14th Amendment right protects a sphere of privacy and the most basic subject of privacy, the naked body. Therefore, given that we have clearly recognized the 14th Amendment right to bodily privacy, the juvenile hall administrative policies, and the training Anderson likely attended, he is not entitled to qualified immunity for the 14th Amendment bodily privacy claim. It was well established. You were specifically trained on this, incidentally, in your training, and you ignored it. So it was well established. So no, you don't get off for this one. When guards themselves are responsible for sexual assault of inmates, qualified immunity offers no shield. In the simplest and most absolute terms, the right of prisoners to be free from abuse is unquestionably clearly established in the circuit, and no reasonable prison guard could possibly believe otherwise. Here's the short version of what's going to happen in 20 years. The Virginia legislature, if they haven't already, is going to ratify the Equal Rights Amendment. I'm not sure if they've gotten around to it yet, but because Virginia does crossover, so they have to wait till crossover day and then ratify it. Then Virginia is going to have a big ceremony about it, probably at the end of the session, which I don't know exactly when that is, but it's coming up relatively soon because Virginia has a very short session. They only meet for like 3 months, so they'll have a big thing about it in late March probably. And they're going to say how wonderful it is and how this is equality and blah, 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 whatever. All right, so then the next step, according to the Constitution, is the National Archivist, which was hilarious because the left was recently trying to fire the National Archivist, which I thought was hilarious because they don't know that this guy is going to be responsible for this, right? The next thing that happens is the National Archivist is going to get it. The National Archivist is going to say, oh, the amendment as passed included this proviso that, it had to be done within a certain time period. It wasn't done within a certain time period, and therefore it's not valid. And then there's going to be a bunch of people who will say this is proof of racism, sexism, bigotry, blah, 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 even though it's just like following the law. Then, at some point in the future, the Democrats will take back both the House and Senate, and they will pass a resolution. I know they're trying to do it right now, as a matter of fact. They've proposed this resolution. It won't get anywhere because it's not going to pass the Senate. But someday they're going to control the House and Senate, and they're going to pass a resolution that says we are retroactively determining that the thing for the Equal Rights Amendment was all good. And then there's going to be a legal debate as to whether or not that's possible. And I'm not 100% sure on the outcome on that one but my best guess is that the court says it's a political question and doesn't do it. That's my best guess because, constitutional amendments override everything. They're political in nature, they're political in process. And so I think the best conclusion is that Congress giving it retroactive effect is valid and we can't hear it because of political question doctrine. So then at the end of that Supreme Court case, which will be about 5 years from now, give or take, at the end of that Supreme Court case, 5 years from now, then everyone will have even more cheers and more things. And, and then the thing goes into effect 2 years from the date it was ratified. And someone has to figure out exactly what that means in this context. Because what does that mean? 2 years from the date of the last legal challenge or 2 years? Probably, just as a name of convenience. So yeah, it probably goes into effect 2 years after the Supreme Court hears it. But someone has to make that decision because in the text of the thing, it's 2 years after it becomes effective. So then the National Archivist publishes it in the Federal Register. It becomes part of the Constitution. Everyone gives a bunch of speeches and is super, super happy. And then 2 years after that, so now we're 7 years into the future, 2 years after that, the Equal Rights Amendment becomes effective. And it's part of the Constitution. And then we're off to the races. Then the men's rights activists are going to use this clause and beat everyone to death with it. And they're going to be like, "Oh no, that's not what we meant." All the way the police deal with domestic violence, all that will have to be changed. Divorce will have to be impacted. Child custody will be impacted. The draft probably is impacted. Not that I think it's that big a deal, really, but the draft will be impacted. Even like other laws will have to be impacted, like Title IX could potentially, Title IX already says not on the basis of sex, so there's whatever, but like the Violence Against Women Act, someone was saying that the Violence Against Women Act doesn't actually have anything to do with women when you actually get into it. So the Violence Against Women Act apparently does nothing to actually protect women. But assuming it does, the Violence Against Women Act is now unconstitutional because it's based on the basis of sex. And any sort of program, any sort of scholarship administered by any state university or government entity for women is now invalid because it discriminates on the basis of sex. Any like female spaces in colleges is probably gone. Can you have sex segregated dorms in colleges? That's debatable. Probably not, because now we're under strict scrutiny analysis, so we're in a whole other world of pain. So, and the idea of female exclusive spaces is gone if there's any government action. What else? Yeah, I don't really see, and the best argument the feminists have is equal pay, but there's already like 3 federal laws that says they should get equal pay. So I don't know that there's anything to be done there. And besides, the Equal Rights Amendment, by its terms, only applies to governmental action, not private action. So if your argument is we're not getting equal pay at this private entity, the Equal Rights Amendment has nothing to do with it because it's private action, not state action. So from where I'm sitting, I'm not seeing a lot of benefit to the left in this, and I'm seeing a lot of things the right can do to make the left regret they ever thought of it. So that is my 20-year prediction for how this is going down. Yeah. 7 years from now, the men's rights people will beat everyone to death for the next 15 years. And then 20 years from now, everyone will be saying, "Oh my God, what did we do?" That's what I think is going to happen. It would outlaw affirmative action, at least as it relates to women, for sure. Well, no, that's not fair. Because the affirmative action cases for race are also judged under strict scrutiny, and they have so far passed muster. But the Supreme Court wants to reverse that. I know they do. They want to reverse that, and they want to ban consideration. So on the premise that they will ban affirmative action for race in the near future, which I think is a reasonably safe bet, then yes, it would also be illegal to have affirmative action on the basis of gender. Because they both be strict scrutiny, it would be the same analysis. So yeah, assuming they overturn it for colleges, which I think is likely, it's also unconstitutional to have affirmative action for women. Yes, and Jack, you're absolutely right. It is written to be incorporated against the states from the start. It's in the text. It actually says, neither the United States nor any state shall. It's very clear on its text. There's no incorporation issue. So no, you don't have to do the 14th Amendment incorporation analysis because the incorporation is done in the text of the Equal Rights Amendment. It's in the text. So it absolutely applies to states immediately because it's clear in the text it does. So you don't have to do your normal incorporation analysis. You're done already. That was easy at least. So I don't really see the good case for the progressives for this amendment. It feels to me at least like they've already gotten everything they want that this law would be doing. Really, seriously, what would this constitutional amendment, if it came to power, what would it be doing for you, progressives, that is not already being done for you? What out there is a law or a regulation or a state action that is in any way discriminating on the basis of sex that we want to eliminate? What is the thing we're trying to do? What is the reason for this amendment to exist? If someone can tell me what the progressive case for this thing to exist in terms of ending state action, because it's only state action, it's federal or state. So in terms of ending government action, what is the best progressive case? Because I can't think of one. I can think of how the conservatives can use it and will use it and make the progressive sad, but I can't see the progressive case for it. It doesn't make sense to me. If anyone sees a progressive case for it, remember, government action, not private action, government action. So we're looking for some rule, some regulation, some statute, some executive who's being biased in some way, government action that's discriminatory that we're trying to fix. What is the government action we're trying to fix? Anyone got anything? Because I got nothing. Anderson argues that his alleged conduct, including sexual comments and conduct, is not equivalent to sexual abuse that we have found to be unconstitutional, you don't say. Yet in Fontana, we noted that the alleged similar conduct was malum in se, I'll come back to that in a second, and that no reasonable officer could believe that this conduct did not violate the plaintiff's constitutional right. So malum in se, sometimes incorrectly called malum per se, even though it means literally the same thing. It just means malum in and of itself. It is bad inherently. The other alternative is malum prescriptionem. I think I'm getting that right. Malum is bad, right? Because malice. Malum means bad. So malum in se means when you say something is in se or per se, you mean of in and of itself. It is bad because it's bad, basically. It's psychological reasoning, but we don't need further justification. Malum in prohibitum is where you say something is bad because it's illegal. So, a really good example, or at least an example, would be like the difference between, I don't know, murdering someone and going 60 miles an hour in a 55. All right? Murdering someone is malum in se. We don't need justification for why it's bad. We don't need any rationale for why it's bad. It's bad. End of analysis. No problem. We're done. Whereas like the speed limit thing is malum in prescription because it's only bad because the state has defined it at that level and they could have defined it at somewhere else or not had the law at all. So it's only bad because of rules. So here they're saying it's malum in se, which is to say it is fundamentally at its core rotten and evil, which I tend to agree. And beyond the clearly established case law, training, and juvenile hall policies, it's obvious that a juvenile corrections officer should not sexually harass or abuse a juvenile child, as it's always wrong for the juvenile corrections officer to engage in the conduct. Accordingly, we conclude that Anderson is not entitled to qualified immunity for Vasquez's bodily injury or punishment claims. With the actual prison guard out of the way, we now have to consider what liability, if any, there is for the supervisors or potentially the prison itself. Now, in a 1983 cause of action, you don't normally have responsibility to the superior respondeat superior, as it's called, or vicarious liability. You don't have transferable liability. That's the normal rule. Is that the rule here? Let's find out. Appleton sought summary judgment of Vasquez's claim for relief for superior liability or for supervisor liability under 1983. Although there is no pure respondeat superior liability under 1983, a supervisor is liable for acts of his subordinates if the supervisor participated in or directed the violations, or if he knew of the violations of subordinates and failed to act to protect them. From the evidence, a jury could find that Appleton, the supervisor, knew or reasonably should have known of Anderson's violations and failed to act to prevent them. Thus, viewing the evidence in the light most favorable to Vasquez and making all justifiable inferences in her favor, we hold the district court erred when it concluded that there was no evidence supporting a causal link between Appleton's conduct and Anderson's alleged violation of the constitutional rights. One of these days, I will get the difference between causal and causal straight. One day. The district court erred when it granted Anderson and Appleton's motions for summary judgment. Because we conclude the district court erred in granting the summary judgment, we need not consider Vasquez's argument the district court erred when it imposed costs. Accordingly, for the reasons described, we reverse and remand for further opinions consistent with this. So that is the end of the case of Samantha Vasquez versus the County of Kern. In this case, we learned that a male prison guard was conducting himself in a way unbecoming of a prison guard. He, a 45-year-old, was watching she, a minor, in an all-female section of the prison as she showered and did other things and encouraged her to drop her current boyfriend and become a boyfriend of someone else like him, and all kinds of super creepy stuff. The district court said that this was totally okay, that this didn't violate Vasquez's interests, and even if it did, it is totally not actionable because of qualified immunity. The Court of Appeals thankfully reversed. They said, no, district court, you got this completely wrong. This is enough to violate her privacy, assuming all the testimony is true, because remember, we haven't had a trial yet. We're just assuming facts at this point. So we haven't had a trial. But assuming everything that she says is true, assuming all the evidence is there, assuming a jury believes her, then yeah, there's enough here. So go back to trial, figure out if a jury believes her, and figure out if you're on the hook for being a creepy 45-year-old guy, or in the alternative, I suppose, whether or not you're making this up and, he actually did nothing wrong. But that's what juries are for, to figure that stuff out, and we will see what happens next. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.